Day 3 of the Trump impeachment crisis, and it just got worse. 45 minutes ago, the President of the United States stood in front of cameras, looked directly into them, and told the entire country that he will not comply with a federal court order. Not through his lawyers, not through a legal filing, not through a spokesperson reading a prepared statement. Personally, publicly, on live television, he called the judge incompetent. He called the arrest warrant unconstitutional. He said, and these are his words, "No court has the authority to arrest a sitting president." 8 minutes. That is how long he spoke. 8 minutes of open defiance broadcast to every news network, every social media platform, every corner of the internet simultaneously. And in those 8 minutes, this situation transformed from a legal dispute into something American history has never seen before. A sitting president under an active federal arrest warrant going on camera to announce he will ignore it. 45 minutes from the moment he finished speaking to right now. That is how fast this escalated. One moment we had a legal question working its way through appeals courts. Lawyers filing motions, judges scheduling hearings, the slow machinery of the judicial system doing what it does. The next moment we had a constitutional crisis playing out on live television in real time with no script, no precedent, and no clear path forward. This is not normal political news. This is not another Washington controversy that gets replaced by the next one in 48 hours. This is the moment America finds out whether the rule of law actually applies to everyone or whether a sitting president can simply look at a federal judge's order and say no. 3 days. 12 major developments, each one more significant than the last. And today, day 3 just became the most significant of all. Here is where we are right now. Trump is under an active arrest warrant issued by federal judge Margaret Chen for contempt of Congress. He claimed executive immunity. Courts rejected that claim. He appealed. Courts rejected the appeal. And then, rather than comply, rather than negotiate, rather than find any path that did not involve open confrontation with the judicial branch of the United States government, he walked to a microphone and told the world he would not follow the order. Congress is now in emergency discussions. Some members are calling for an immediate impeachment vote tonight. Others are demanding negotiation. Others are telling their colleagues to wait and see what the courts do over the next 24 hours. An appeals court emergency hearing is scheduled for Saturday morning at 9 a.m. 3 federal judges will convene to rule on whether a sitting president has constitutional immunity from judicial process. The Attorney General has taken the formal position that the president cannot be arrested while in office. And the video of Trump mocking Judge Chen has been viewed 47 million times in 3 hours across TikTok, YouTube, Twitter, and Facebook combined. That is where we are. Now let me show you exactly how 3 days turned a congressional subpoena into the most serious constitutional crisis since the Civil War. 4 weeks ago, the House Judiciary Committee issued a subpoena to Trump for testimony about alleged abuse of pardon powers during his previous term. Documents had surfaced suggesting he allegedly pardoned individuals in exchange for financial payments. A constitutional law professor testified before the committee at the time and said, if Trump ignores this subpoena, the courts will have to decide if a sitting president can be jailed for contempt. That statement was treated as theoretical, a hypothetical extreme. The kind of thing legal scholars say to illustrate constitutional stakes, not describe likely outcomes. Nobody in that hearing room genuinely believed we would be here 3 weeks later. But here is what happened after that subpoena was issued. Trump claimed executive privilege. Judge Chen rejected that claim and ordered compliance. Trump missed the first compliance deadline. Judge Chen ordered him to appear in court. Trump missed the second compliance deadline. Judge Chen filed contempt charges. Trump's legal team appealed the contempt finding. Appeals court upheld the contempt finding and said Trump had to comply. Trump escalated to a higher court. Higher court upheld the finding again. At no point in this entire sequence did Trump's legal team attempt to negotiate a middle path. At no point did they offer partial compliance, a modified production schedule, a good faith gesture of any kind. Every single response was escalation. Fight harder, claim broader immunity, make bigger arguments. And every single time, courts said no. Wednesday, May 20th, day 1, 2:33 in the afternoon. Judge Margaret Chen issues an active arrest warrant for Trump for contempt of the congressional subpoena. She stated 6 words from the bench that changed the entire frame of this situation. The president is not above the law. She signed the warrant herself, did not delegate it, did not send it through a clerk, signed it personally. The White House counsel issued a denial within 4 minutes, which means they had the statement prepared in advance. They knew this was coming and they chose to fight rather than comply. Senate Republican leaders called for emergency negotiation to avoid crisis. House progressives demanded immediate arrest. The political establishment went into shock in real time. 53 minutes. That is how fast the institutional response came from both parties simultaneously. What almost nobody noticed in the coverage on Wednesday was that Judge Chen's warrant included specific language anticipating the immunity argument before Trump's team even made it. She wrote that her enforcement authority extended to any person, including sitting presidents. She did not write that language as a legal formality. She wrote it because she knew exactly what was coming and she wanted it on the record before it arrived. Thursday, May 21st, day 2, 7:15 in the morning. Trump's legal team files an emergency appeal claiming executive immunity from all judicial process. Not immunity from this specific warrant. Not immunity from this specific contempt charge. Immunity from all judicial process. The argument was that sitting presidents cannot be arrested or compelled by courts under any circumstances while serving in office. That argument had never been directly litigated in American history at this level. Courts had addressed presidential power and judicial authority in various contexts over 250 years. But a sitting president explicitly claiming he cannot be compelled by courts under any circumstances, filed as a formal legal motion, was new ground. Judge Chen's response was to schedule an expedited appeals hearing for Saturday morning. Not next week, not after briefing schedules and filing deadlines and the normal rhythm of appellate practice. Saturday morning, 48 hours from the filing. She refused to let this stretch out. She understood what delay meant in this situation, and she chose speed. 3 federal judges were pulled into an emergency panel review. The Attorney General took a formal public position that the president cannot be arrested while serving in office, creating a direct institutional alignment between the executive branch and Trump's legal argument. International media began treating this as a potential constitutional breakdown. BBC, Reuters, Le Monde, every major international outlet had correspondents working the story by Thursday evening. The story split from one contempt case into 3 simultaneous constitutional crises, all moving at different speeds, but all connected at the core. Friday, May 22nd, day 3. Today, 11:47 in the morning, Trump holds a press conference. He does not send his lawyers. He does not issue a written statement. He walks to the microphone himself, and for 8 minutes, he dismantles any remaining possibility of a quiet resolution. He calls Judge Chen's arrest order an absolute disgrace. He says it is unconstitutional and claims he will not comply with it under any circumstances. He calls her incompetent. He suggests she is politically motivated and acting as an instrument of his political opponents. He says directly to the cameras, they cannot arrest a sitting president. It is unconstitutional. Everyone knows it. He says judges should stick to their lanes. Then he walks away. 47 million views in 3 hours. No clarification from the White House. No walkback from his legal team. No Republican leadership statement defending the position or distancing from it. Silence from his congressional allies, which is itself a signal. Here is why today is categorically different from Wednesday and Thursday, and why the distinction matters more than most coverage is acknowledging. Wednesday was a judicial action, an arrest warrant, something that happened in a courtroom, documented in a legal filing process through the machinery of the court system. Most Americans experienced it as news about a legal proceeding, something happening in a world of lawyers and judges and documents that felt distant from daily life, even if its implications were enormous. Thursday was a legal argument. Trump's team claimed immunity. They made the argument through attorneys, in documents, filed with courts, in the language of constitutional law. It was abstract. It was a position taken on paper in a proceeding most people would never read. Today is an executive action, a public statement, a direct confrontation. A sitting president personally announcing on camera that he will not obey federal court orders. That is not a legal defense. That is not a constitutional argument. That is a president telling courts to their face that he will not follow their orders. 3 things became irreversible the moment Trump finished speaking. Before today, this was a confidential legal dispute that could theoretically have been resolved quietly behind closed doors through negotiation or modified compliance or any number of paths that did not require public confrontation. After today, it is a public standoff broadcast on every platform globally. There is no quiet resolution available anymore. The confrontation is public record. Before today, Trump could claim his lawyers made the immunity argument and he was following their legal advice, maintaining distance between himself and the defiance. After today, Trump personally said he will not comply. That is not a legal defense. That is an admission of defiance from the president himself. Before today, courts could still reasonably hope that sustained legal pressure would eventually produce compliance. After today, the president pre-announced he will not comply regardless of what appeals courts decide Saturday morning. Courts are now in a position where they must enforce their authority or openly acknowledge they cannot enforce it against a sitting president who controls the agencies that would carry out enforcement. This is not a loop that closes gently. This is three separate tracks, all moving toward a single point of collision within the next 24 hours. Track one is the federal court enforcement question. Judge Chen issued a warrant that is legally valid and currently standing. Trump claimed immunity from judicial process. Saturday morning at 9 a.m., an emergency appeals panel of 3 federal judges convenes to rule on whether sitting presidents have constitutional immunity from judicial compulsion. If they rule no immunity exists and Trump must comply, the question immediately becomes whether federal marshals will actually go and arrest a sitting president, whether they will remove him from the White House, how that works legally and practically and politically when every federal law enforcement agency ultimately reports to the executive branch that the president controls. Track 2 is the House impeachment response. The House Judiciary Committee is investigating Trump's defiance of court orders and his conduct around pardon abuse allegations. Some members are demanding an immediate impeachment vote. Others want to wait for the Saturday court ruling. Others are arguing that impeachment without conviction in the Senate is meaningless theater. Emergency House leadership meeting is scheduled for Saturday evening to decide strategy. The constitutional question they must answer is whether a president openly defying federal court orders on camera constitutes an impeachable offense under the high crimes and misdemeanors standard. The answer among constitutional scholars is almost certainly yes. But Congress has to vote. Congress has to act. And the political calculation inside that vote is complicated by a Senate where conviction requires 2/3. Track 3 is the executive versus judicial separation of powers crisis that the Attorney General's formal position created. When the Attorney General officially declared that sitting presidents cannot be arrested while in office, he did not just state a legal position. He aligned the entire executive branch enforcement apparatus behind Trump's defiance. The FBI reports to the Attorney General. The U.S. Marshal Service reports to the Attorney General. The Attorney General reports to the President. If Saturday's appeals court orders arrest and Trump refuses, the only people who can physically carry out that order all work for the man the order is directed at. That is the constitutional deadlock. That is the structural problem that no legal brief and no court opinion can resolve on its own. These 3 tracks are not running separately. They are synchronized in ways that mean the outcome of each one directly determines what happens in the others within hours. If track 1 produces a Saturday court order for arrest and Trump refuses, Congress faces immediate and irresistible pressure for an emergency impeachment vote, and every law enforcement agency must choose publicly between the president and the court. If track 2 produces a House impeachment before Saturday's court ruling, the constitutional calculus for every federal agency shifts immediately because an impeached president's authority over enforcement agencies becomes legally contested. If track 3 produces an explicit refusal by the Attorney General to enforce a court order, both Congress and the courts face the same question simultaneously and must respond. There is no sequence where these tracks resolve one at a time over weeks. They are all reaching critical pressure points within the next 24 hours, and they are all connected to each other. Now step back and look at the 3 people whose decisions actually control what happens next. Trump is in the White House under an active arrest warrant, publicly committed to defiance on camera in front of the entire country. His strategy is a calculated bet that courts will not physically enforce an arrest against a sitting president, that appeals will create enough delay and procedural complexity, and that political pressure will eventually force Congress toward negotiation rather than confrontation. His operational power is real. He controls the agencies. The FBI, the marshals, the Justice Department are all within his chain of command. But courts ruled explicitly that his legal authority does not extend to defying judicial orders. And he has lost something today that legal power cannot restore. He has lost the ability to claim he was following his lawyers. He said it himself on camera. Judge Chen is a federal judge who issued a warrant, scheduled a Saturday emergency hearing, and has watched the president mock her publicly on live television. Her strategy has been to force the constitutional question into the open as fast as possible, refusing delays, scheduling hearings within 48 hours, anticipating immunity arguments before they were filed. Her power is the power to order. She can find contempt. She can issue warrants. She can impose sanctions. What she cannot do is enforce. There is no mechanism within the judicial branch to physically compel compliance when the executive branch refuses. That gap between ordering and enforcing is the space where this crisis lives. Congressional leadership is trying to find a legislative solution to a problem that keeps outrunning legislative timelines. Their power is impeachment. If the House impeaches and the Senate convicts, Trump is removed from office. The immunity argument evaporates. The enforcement problem disappears. But impeachment requires votes. Votes require political will. And political will inside both chambers right now is complicated by silence from Republicans who 2 days ago were publicly supporting Trump's legal challenges and today have nothing to say. Look at the historical weight of what these 3 days have produced. No sitting president in American history has ever faced an active arrest warrant. Presidents have faced impeachment. Presidents have faced congressional censure. Presidents have had their policies overturned and their executive actions blocked and their nominees rejected. But no president has ever had a federal judge sign an arrest warrant with their name on it. And no president has ever responded to that warrant by going on television to announce personally that he will not comply. The pattern that established this precedent, or rather the pattern that shattered 250 years of assumption, follows a logic that becomes clear when you watch all 3 days together. Day one, courts issued a warrant and constitutional question became a legal document. Day two, Trump claimed immunity and legal dispute became a constitutional argument. Day three, Trump announced defiance on camera and constitutional argument became an executive confrontation. Each day removed one more layer of abstraction. Each day made the collision more concrete and more inevitable. Each day closed off one more path to quiet resolution. Historians will look at this week the way we look at other constitutional inflection points. The moments where theoretical principles about how government works got tested against actual human decisions made under pressure in real time. The question that gets answered this weekend is not really about Trump. It is about whether courts have actual enforcement power over the executive branch when the executive branch decides not to cooperate. If Saturday's court orders arrest and federal marshals execute it, courts have real power and separation of powers functions as designed. If courts order arrest and Trump refuses and nothing happens, the judicial branch just discovered in public that it cannot enforce its authority against an executive who controls enforcement. If Congress impeaches before courts can enforce, the legislative branch acknowledged that courts needed help and intervened. Every outcome from this weekend becomes the precedent that defines what American constitutional government actually is, rather than what we assumed it to be. The next 24 hours are not political drama. They are a live constitutional stress test with no guaranteed outcome and no historical script to follow. Saturday morning at 9 a.m., 3 federal judges will hear arguments on presidential immunity from judicial process. Saturday evening, House leadership meets to decide whether to call an emergency impeachment vote. Sunday, every timeline converges. Right now, 47 million people have watched the president say he will not comply. Courts have a warrant they cannot enforce without executive cooperation. Congress has a vote it has not yet taken. The Attorney General has a position that aligns the enforcement apparatus with the president, and 3 separate constitutional crises are running simultaneously toward the same 24-hour window. This is the moment, not a moment like this. This moment, the one happening right now, where everything that Americans have assumed about how their government works, about courts and presidents and the rule of law and who answers to whom, gets tested against a situation nobody designed a procedure for because nobody believed it would actually happen. By Sunday, we will know. Subscribe. I will be covering every development from Saturday's 9 a.m., hearing through Sunday's resolution in real time the moment it breaks.